You're welcome back, and the conversation we're going to have is something that's very important, especially for a bank account holder. And if you are listening, of course, I'm sure by the time we are done with this conversation, you might want to have some amendment to your bank details, and of course, something that you need to do in the event that you are no longer available and somebody must take over your account. The Bank of Ghana has some details for it. Now, the Bank of Ghana is dispelling a widespread misconception that being named as the next of kin grants automatic access to a deceased relative's bank account. Now, contrary to popular belief, the bank says the only legitimate means to accessing these funds are through the execution of a will or the formal administration of the estate. The Bank of Ghana deems this clarification critical to inform Ghanaians about the proper legal procedures in the management and inheritance of financial assets. Thankfully, the Assistant Director for Financial Stability Department with the Bank of Ghana, Augustine Amwako-Donko, joins me in the studio. And of course, we're going to put a number on the screens. If you have a question, send us a WhatsApp so that I can share with Mr. Amwako-Donko as we go through this very important subject, especially if you are an account holder. Mr. Donko, you're welcome.
Thank you very much.
So why this clarity?
Thank you. So we have observed from our public education activities across the country over the years that there is this misconception.
Okay.
So sometimes you are out there engaged in financial literacy activities. When it comes to the questions and answers session, even when you may not have even discussed this or mentioned it,
it will come up.
It will come up. You know, somebody will ask a question or make a comment which will suggest that that person believes that the next of kin that they would have appointed is the one who is going to take over that account in the event of their death. You know, and over the period we have tried to dispel this misconception. So the bank agreed that probably it is time to come with this publication to help, you know, correct this misconception, because we do not want people to be, shall I say, disappointed when it comes to the a time when they believe that they have to go take over an account, and then that cannot be done.
That cannot be done.
I remember a particular incident where in one of our interactions with, I've forgotten exactly the group of people, during questions time, this guy came and shared this experience that even in his case, his father was still alive. He was the next of kin. He said his father didn't like going to the bank. Okay. So he was doing everything. The posties,
on behalf of the father.
Whatever. Yes. And so the bank there, everybody knew me. Everybody knew me that this account, I'm the one who will praise, even though it's not mine. And he said on one occasion, from returning from wherever he went, he decided to pass by the bank.
To withdraw some money?
To check the balance.
Okay.
Okay. And then the bank refused. And he reminded them that you all know me, that this bank, this account, I operate it. In addition, I'm the next of kin. I just want to know the balance. You know, so he was quite furious and unhappy. And so he brought it up at that program I'm referring to. So it appears, and unfortunately, it's a lot of people. It's a lot of people assume that you're being nominated as a next of kin grants you automatic access to that account in the event that that person
it's not available.
It's not available.
It's dead. And now you say that that is not the case.
That is not the case.
So first, let's try and establish why the bank demand that you provide such response when you are opening an account. Why is it so that you provide next of kin if that next of kin cannot inherit that account in the event of death?
Yeah. All right. So, you know, as part of what we call the know your customer issue, when you are having a relationship with a bank, there is this regulatory requirement on the part of the bank to do a bit more to get to know you. Okay, so that is how come when we are opening accounts, they give us these forms, and you have to supply a lot of information, your name, your date of birth, where you work, your telephone number, and all those things. The bank or the financial institution would like to know more about you. Then the question about the next of kin. So you are asked to provide this next of kin. The primary duty or the role of the next of kin is to be a go-to person when it comes to the time when the financial institution is finding it difficult to establish contact with the account holder.
Okay.
So give us one person such that anytime we want to contact you, but for whatever reason we are unable to, we can fall on that person to either help us reach you or perhaps help us with the information or whatever assistance that we need concerning our business with you.
And not necessarily because the person must inherit the account.
No.
That's always been the case.
No, that has always been the case. So people keep asking, why are you changing the directive now? Why are you? It is not as if it didn't used to be the case and now we are. No, the next of kin has never been a rightful heir to the account. No, this is how it has always been, except that unfortunately it appears the misconception had been there for long.
So now, if the next of kin cannot automatically inherit an account in the event of death, what is the process for inheritance?
Okay, yeah. So, like somebody said, if you open an account, it is only you, the bank or the financial institution knows. Okay, the financial institution will only act on the accounts based on you and only you, the account holder's instructions. So once you pass on, definitely you are not available to issue instructions. The financial institution will only act on instructions from the courts. Okay, yeah. So there are two scenarios. First of all, if the account holder dies and then leaves a will, the person whose name is mentioned in the will to take over that account is the one that the account will go to. But even for that person, it is even not automatic that just because your name is mentioned, probably you take the will, you walk to the financial institution.
What must you do then?
Claim it.
What must you do then?
There is a legal process you go through. Okay, so you go to the court and then you go through a process I think the lawyers call probate to obtain a probate. Okay, that is what will empower you to now have access to the account. So where an account holder dies with a will, this is the process the person who is named in the will to take over the account will go through.
So it is a will that will give you the legal right to access the account.
Exactly.
After going through the legal procedure.
After going through the legal procedure. That is when there is a will and then you are named in it. The second scenario is when the account holder dies without leaving any will. He dies interstate, yeah. So in that situation, again, their relatives or whoever believes is an interested party can also go through the legal process, obtain, I think what they call letters of administration. That will also empower them to have authority over the estate of this person, including the accounts in question. So with the letters of administration granted by the bank or the financial institution, you are now empowered to go and then begin the process of assessing the funds. Okay, so I think the other reason why people become a bit excited, emotional, worried about this situation is they assume that if the next of kin cannot have access to this account, then it means the funds are lost.
Exactly.
The family. No,
exactly.
The funds will never be lost. You go through these two processes I've outlined, you will definitely receive the money. Somebody was asking, what if these persons go through these processes, but for whatever reason, they are unable to access the account? And I was saying, I mean, if they go through the right processes, obtain the relevant, appropriate documents, I cannot readily think of any situation
where they will not have access to that.
Except where perhaps there is an issue with the account itself. Maybe the account is under investigation by authorities, Yoko, security services, maybe Bank of Ghana, whatever. Then that is a different issue. But granted that there are no such situations, once you have gone to the legal process and obtain your documents, you will readily have access to it. But even if, for whatever reason, this situation happens, still the account is not lost. What happens is, so now the account holder is not available. He's passed on. So definitely the account is not going to be operated. The account is going to be inactive. Now, in the banking system, if an account is not operated by the account holder for a period of 2 years, the account becomes dormant. Okay, and so it should be moved. The financial institution will move it to what we call a dormant register.
And then the money?
Yes, so it's the money that is moved into this special register we call a dormant register. The reason why this is done is that such accounts become vulnerable. Okay, so we would want to give it a higher protection.
Okay.
Once it goes there, one characteristic of a dormant account is that no money can be withdrawn from it. Okay, for about 2 years, we haven't seen the account holder, and therefore we are not sure who
whether the
is
person
coming. Exactly.
Yes.
So for any withdrawals to be made on a dormant account, that account will first have to be reactivated. So in this situation, in our discussion, the person who can reactivate the account is no more. So it means this account is going to be idle for a long time. Now, if after the 2 years that the account has become dormant, another 3 years elapsed.
5 years.
So now it is 5 years. We have still not been able to establish any contact with the account holder. The regulations require that the financial institution should now transfer these funds to the central bank.
To Bank of Ghana.
Bank of Ghana for safekeeping.
Safekeeping for who?
Thank you. Safekeeping for the account holder if they are still alive, but except that we may not have been able to find them out, or even if they are deceased, for whoever has rightful access to it. So in the example that we gave, this account holder has passed on, all this time has passed, so the accounts are now with Bank of Ghana, or even before it is moved to Bank of Ghana, it is still with the original financial institution. What the relatives can do is go to the legal processes that we have mentioned already, and then they go to the bank or the financial institution to have the funds. In a case where the funds would have been transferred to Bank of Ghana, same. Once the relatives of the deceased get or are able to establish that, oh, uncle had this account at so and so bank, they would just have to go through the legal processes, because in this case the person is no more. Okay, so once you have the necessary legal documents, you go to the bank to make a claim. You'll be given a form, you fill, the bank will validate it, find out whether indeed that account existed, how much is in it, what you're asking for is yes. And then once they validate it, they will send it to Bank of Ghana. We will also do a validation. And then once it is passed, everything is okay, we will transfer these funds back to this financial institution so
the person can access the account.
Exactly.
What if after 2 years, after the 5 years, nobody shows up, 7 years, 10 years, what happened to the money?
Yes. So once the money gets to, and that is one of the reasons why we came out with this
Publication.
Regulation for the funds to be transferred to Bank of Ghana. In the past, it didn't used to be that, but we will have a lot of complaints from some members of the public. They will come saying, I traveled outside the country, I've been out for 6, 7, 9 years. At the time I was leaving, I had this
account here
with this amount. Now after 9 years, I have come to make a claim, and the bank or the financial institution is telling stories. They can't find my funds, my balance, which used to be so and so, is now zero, that kind of thing. So now we have said that once an account becomes dormant, I have said that one characteristic of a dormant account is that nobody can make a withdrawal from it. Also, a dormant account will not attract any charges, any bank charges. Yes, okay, because we don't want a situation where an account that is dormant is inactive, it's not being operated. Because of bank charges,
it will take away everything.
Gone, yeah, so the account is dead. Now, when it comes to Bank of Ghana, the idea is for, maybe I can even say, perpetual protection. The accounts will sit with us maybe till the kingdom come. Yes.
Right.
The idea is that we want to ensure that at any point in time, that a relative or any person, any interested person, is able to identify that this our deceased relative had these funds here. They can always come
for it.
It is not lost. They can always come for it. In fact, currently, to even make it easier for all of us, Bank of Ghana has a portal on its website where, so let's say you lose a relative, an uncle, parent, you did not know anything about their banking activities. Okay, they may have had some account somewhere, but you never knew. So now you are sitting down and then you are asking yourself, so uncle didn't have any
account anywhere.
Maybe he had, though, just that he didn't tell us. You can go to this portal and then do a basic name search. Okay. Now, once you do the name search and then it pops up that, oh yes, Kofi Mensah had an account with, let's say, ADB. Yes. You can go to ADB, have that discussion with them,
and then they'll find a way
they'll find a way of...
Mr. Donko, let's get interactive on this matter because it's very important. Somebody just sent me a text message. He says that why, he went through similar issue. There was a will, they went through the legal process. The court is demanding 10% of the amount of money deposited in the account before they can allow it to go. Is it lawful?
So,
but before I answer that question, let me bring in Kofi from Adan. Kofi from Adan, good evening, welcome to the post. What is your question or comment?
Before I answer that question, let me bring in Kofi from Adan. Kofi from Adan, good evening, welcome to the post. Yeah, my comment is slightly different.
Kofi, if you have a TV set close, can you bring it down?
For me, if you open an account, let's say a dream account, a dream account for your minor child, and then when you are no longer around, the account is in your name and the minor child is attached to that account. And the minor child automatically gets that access to the money.
Kofi, we didn't quite get you right. Can you rephrase the question?
So you open, there is something they call a dream account for children.
Yes,
children below the age of 18. Now, when you open such an account for that child, in your absence, can the child have direct access?
Can the child have direct
access? You're asking whether the child can have direct access to the account?
In the absence of,
even though,
in the absence of the parent.
Right. So, yeah, okay. So the question is, if the parents are no longer, they are deceased, can the child have access to the account?
Okay. So this account is open for
the child.
The child. But because
likely an investment account.
Yes. Because the child is a minor, he is unable, legally to operate such an account. So the parent who opened the account is the one who is going to be operating the account on behalf, or like they say sometimes, in trust for the minor. Now what happens is, when the minor obtains the legal age, I think of 18. Yes, then he will now be able to operate this account. So they'll go to the financial institution and then the necessary changes to be done for this person who used to be a minor but now has obtained the legal age to now be the account holder, so to speak.
But until you are 18?
Until you are 18, you'll be unable to do that. An adult will have to hold the account in your name, yes. Okay, so once you are 18 and then you go to the bank, then the necessary changes are done, you will be able to, yeah. But I think what he's asking is, if before the child obtains 18, this adult, the parent who opened the account, probably passes on whether the child can have access to the account. So in that case, yes, except that because he's still a minor, the account is for this child.
Yes.
But because he's a minor, he's unable to operate it. Okay, so the bank will hold the account for this person until all the terms and conditions governing that account will remain, but until that person attains the required age, and then
it cannot happen. The earlier question
the earlier question
about the court demanding.
Yes, I think it borders more about the legal processes. Maybe that is. I'm not sure what the 10% is for, but I want to assume that perhaps it is part of the legal procedures. From our end, I'm not aware of any such requirements. From our end, if you are coming to reclaim your fund or whatever, there's no charge. But I want to believe that this is purely part of the legal procedures.
Administrative charges.
The judiciary
there are a few questions. Someone says, hi, so why don't the banks add who will take over the accounts when completing the forms so take off the next of kin and replace it with who will take over that account. I'm sure that can only happen when there's a will.
Yes.
In the event that there's no will, this does not arise at all. Somebody said, what happens if the deceased doesn't mention the account in his will? Meanwhile, there's a next of kin in the bank record. Before you answer, from Tamale, Nana, good evening. What is your question?
Okay, good evening. My question is, my dad passed on 2017, and he had some shares with Data Bank. So I wanted to ask if it's still accessible to now, because after that I couldn't access it because I didn't have the document. So I want to ask, is the share still accessible now, or it has been absorbed into the system? That's invalid.
Thank you very much, Nana. Is there a response for him?
So, unfortunately, Data Bank is in the space of the security sector. Okay, it's on the capital market under the regulation of Securities and Exchange Commission. Okay, so I would advise Nana to direct his queries there. Data Bank is not a bank being regulated by Bank of Ghana, so I may not be able to speak to it. I don't know how the operations are like. Yes, if it were a bank or a financial institution regulated by Bank of Ghana, then probably we could discuss it. So I advise that you reach out to SEC, Securities and Exchange Commission, and then you can have that discussion with them.
A few questions. Okay, so it says almost what happens if the deceased doesn't mention the accounts in his will? Meanwhile, there's a next of kin. Somebody is making an allegation that sometimes people move money from here and put it there. Unless there's evidence, we cannot go into that. Bright says, why is it that the bank tries to reach the account holder through the next of kin, and this same next of kin cannot help the concerned family to get find any documents on the follow-up?
So in fact, that could be even one of the rules of the next of kin. Okay, because in addition to what you have said, that they are there to provide assistance to the financial institution in times when the account holders cannot be reached. One, if you extend it, one of their duties is also to more or less oversee the account during times that the account holder is unable to. Okay, even when we take the death aside, supposing this account holder is out of the jurisdiction, or for whatever reason they are not able to, oversee the accounts properly, the next of kin is able to do that. So there's a publication in the media in Ghana that account holders are supposed to do ABC.
Right.
This particular account holder may be out of the jurisdiction, or maybe is on a hospital bed somewhere and may not have access to this media information. It's the duty of the account holder, the next of kin, to pass this information on to this person, so that if there is anything that he can do to help them, exactly. So the question he asks, the account holder has passed on. The next of kin, because you've been around, because you've been close to the account holder and perhaps even the account, you may know a thing or two about it. So, yes, if you have the ability to assist the family to have access to the account by way of the provision of any information. Oh, he used to tell me that he kept these documents on this account here. So probably you could check there and see. Oh, he told me usually for his Ghana card, this is where he keeps it. Any information that you can provide
that can help.
The relative to follow up, that is...
We'll be wrapping up soon. Let me run through some few questions here. Somebody says, if the person, the account holder died intestate, has died without a will, what happens to the account? And then what of an account with no family member is aware of? And he said that there's a provision on your website. If you think that your family member died, you don't have information regarding bank accounts that he or she operated, you can slot in the name there, and then information will come. Perhaps it can help lead to something that you may not be aware of. And then somebody says, that will be, my dad died since 2019, so that we can't access my dad's account. So the issue of person who died intestate, and then 2019 says they've not been able to access the account.
Yes. So for an account holder who dies intestate, as I've indicated, what will happen is for the relatives, the family, to get a lawyer, go to court, and then obtain the letters of administration. Okay, that is all you require. Okay, once you are able to go to the process, obtain a letter of administration, you can now approach the financial institution, and then you start discussions with them. You should get the funds. You should get the funds. for
since 2019,
yes.
what could possibly be the challenge?
So he did not tell us whether they've gone through the required legal process.
Exactly.
Yes, we are aware of situations where people would want to deal directly with the financial institution, particularly in areas where, especially in the area of the rural banking,
right,
where this is more or less community banking. Everybody knows everybody. So they are like, you, the bank officers, you are aware that we are the family of Opini Kwesi. He used to send us here and whatever. Yes, now he's dead. Why can't you, so that may drag the issue. Some of them may believe that you know us, you should give us the money.
Exactly. But it doesn't work that way.
It doesn't work that way. Once you go through the legal processes, obtain the relevant documents, honestly, I cannot see why the bank will not, the financial institution will not give you access to the funds. Otherwise, you can still go back to the court for the court to make some further. But unless you have further information as to why,
exactly,
regardless of the family having obtained all the necessary legal documents, they still cannot have access to the funds. Like I said, except in a few situations where maybe the account itself or the account holder had some issue, okay, such that the account has now been placed under investigation for whatever reason, suspicion of money laundering, whatever.
Exactly.
Security forces are investigating anything. That aside, it should not be difficult to claim the funds once you've gone through the required legal processes.
So basically what you're saying that to avoid confusion and litigation, make a will.
The will
indicate who will take over the account.
Yes. I think the lawyers always advise us that it is very, very important that we do it. For some reasons, people hesitate a bit, but that is it. But aside that, the other important thing that we want to say, unfortunately, people get disappointed when it is said. But this afternoon, I listened to your midday news again. I think you spoke to one lawyer.
A lawyer.
And then in the end, the way he ended his conversation, he said, if you didn't know, now you know. Okay. So that is the unfortunate truth about next of kin. It doesn't give you.
People think that when they are making a will, it's like they are getting closer to their grave.
And I don't blame anybody. Most of us, honestly, even me, until I got into this industry, until I became, I didn't know. At the time we were all opening accounts when we were in school, we made sure the person that we wanted to inherit the funds was the one that we were putting down as the next of kin. We didn't know that wasn't it. But I think now, again, like the lawyer said, for those of us who didn't know, now we know this is it. You being nominated as a next of kin does not grant you automatic access to the funds of the account holder in the case of their death.
All right. Mr. Augustine, I think there are always questions regarding financial issues. So perhaps we may have to institutionalize this so that once in a while we'll have you in the studio to discuss some of this. But I'd like to thank you so much for coming through this evening.
Pleasure.
Mr. Augustine Amwako-Donko is from the Financial Stability Department of the Bank of Ghana. And we've been talking about the next of kin and whether or not that person can inherit your account in the event of death. The information or the rule here is that in the absence of a will, that will be difficult. So to avoid any confusion and litigation, make a will, indicate in your will who should inherit the thousands, the millions in your account when you are dead and gone, so that everybody is clear in their mind how this thing should be handled. This is the pause. We'll take a short break and return.